Forget everything you thought you knew about getting a green card. As of this week, the entire rulebook has been thrown out, and a new, unforgiving era of immigration processing has begun. U.S. Citizenship and Immigration Services, or USCIS, has just unleashed a brutal new zero-tolerance policy. What does that mean for you? It means one tiny mistake on your application, a single wrong date, one missing signature, a document that's a week too old, and your case is instantly denied. There are no more warnings, no more requests for evidence, and no second chances. Whether you're filing for your spouse, your parents, or a critical job that your family depends on, your American dream is now hanging by a thread. The path forward has become a minefield, and most applicants don't even know they're walking through it. In the next 10 minutes, I am going to break down exactly what has changed, who is most at risk of a devastating denial, and the critical steps you absolutely must take before this weekend to save your petition from the shredder. Stay with me, because what you're about to hear could be the difference between a green card and a deportation notice. Let's start with the most dangerous change. Just last week, if an immigration officer found a simple mistake in your file, say you forgot to include a bank statement or used an outdated form, they were required to send you a request for evidence, or an RFE. It was a lifeline. It gave you a chance to fix your mistake and keep your case alive. As of today, that lifeline is gone. Officers now have the full and discretionary authority to deny your case on the spot for any missing initial evidence. Let that sink in. There's no obligation to give you a chance to correct it. You used an old version of the I-864 Affidavit of Support form because it was saved on your computer? Denied. Your birth certificate translation is flawless, but is missing one single sentence of the translator's certification. Denied. You forgot to sign page 7 of a 12-page form. Denied, and your entire application fee is gone. USCIS is calling this a front-end quality update, arguing it will speed up processing for perfect applications. But for the average person, it's a minefield designed to punish the smallest human error. Your petition must now be absolutely perfect from the very moment it lands on their desk. This isn't just about being careful anymore. It's about achieving a level of perfection that the system has never demanded before, all while your future hangs in the balance. So what does a perfect application actually look like in this new hostile environment? The standards have been raised across the board, and the details are everything. Let's get specific. First, vital records. Things like your birth certificate or marriage certificate. It's no longer enough for them to be certified copies. Under these new guidelines, they must be certified copies that were issued within the last 6 months. That old pristine copy you've kept in a safe for years. It may now be considered invalid, triggering an instant denial. Next, translations. Every single document that is not in English needs a full word-for-word English translation. But now it must be accompanied by a very specific translator's certification. This certification must state that the translator is competent to translate and that the translation is true and accurate. If that specific language is missing, the entire translation can be thrown out. Then there are the photos. They must be exactly 51 millimeters by 51 millimeters with a pure white background and a matte finish. No glossy photos. And the rule about no glasses is being enforced with 0 exceptions. If your photo is a millimeter off or reflects a tiny bit of glare, you're giving them a reason to deny you. And perhaps the biggest trap of all, the I-864 Affidavit of Support. This is the form that proves you can financially support the immigrant. It now requires a full 6 months of every single bank statement from the sponsor. Not just the first page, but every single page of every statement for 6 consecutive months. On top of that, you need a job letter on official company letterhead. It must be signed in blue ink, and it must be dated within the last 30 days of your filing. A letter from 31 days ago could be grounds for denial. If this level of detail is already making your head spin, hit that subscribe button right now because you absolutely need to know what's coming next. If you are sponsoring a spouse, listen very closely. The government has reportedly tripled its fraud investigations overnight. They are scrutinizing marriage-based green card applications with an intensity we haven't seen in years. You are now required to provide 4 different types of joint documents for every 6 months you've been legally married. This isn't just about a joint bank account anymore. They want to see joint car insurance, joint health insurance, joint utility bills, joint gym memberships, joint credit card statements, anything and everything that proves you share a real intertwined life together. They want to build a timeline of your relationship, and any gaps could be seen as a red flag. Worse still, they have resumed unannounced visits and interviews with your friends and neighbors. Imagine an immigration officer knocking on your neighbor's door at 7 a.m. and asking if they've seen your spouse taking out the trash or getting the mail. If the person across the hall, who maybe just minds their own business, says they've never seen your spouse, that could be used as evidence to sink your entire case. And here is the most terrifying part. If your spouse is already in the United States, and your family petition is denied for any of these reasons, USCIS is now required to place them in deportation proceedings. Let me be clear, one mistake, one piece of evidence they don't like, one confused neighbor can now directly lead to your family being torn apart. This next part is an emergency alert for anyone with a child who is approaching the age of 21. Mark your calendars for August 15th. This is a critical, non-negotiable deadline. Under a law called the Child Status Protection Act, or CSPA, a child's age can be frozen when their visa petition becomes current, keeping them eligible for a green card as a minor. For years, USCIS has used a more lenient chart, the Dates for Filing chart, to determine when you could file your final paperwork and lock in that age. But as of August 15th, that is over. USCIS will stop using the Dates for Filing chart for this purpose. From now on, only the much stricter Final Action Dates chart will matter for locking in a child's age. For many families, the dates on that chart are months or even years behind the other chart. This means that if your priority date isn't current on the Final Action Dates chart by the time your child physically turns 21, they age out of the process. They lose their place in line and are often pushed into a different visa category, which can mean another decade or more of waiting. It is a catastrophic outcome. If you are even close to this deadline, you must file your adjustment of status paperwork immediately. A few days of frantic, stressful work is infinitely better than another 10 years of separation. For everyone in the employment-based categories, from tech workers to nurses to investors, the August 2025 Visa Bulletin was a horror movie. The volatility is staggering, and it's catching thousands of people off guard. EB1 for India and China, a category for individuals with extraordinary ability, just jumped backward by 11 months. People who thought they were weeks away from getting their green card suddenly find themselves a year away or more. The popular EB2 category also retrogressed, meaning the line moved backward, adding unexpected delays for skilled workers and professionals. And the EB4 category, for religious workers and other special immigrants, became completely unavailable because the yearly quota ran out in an instant. The doors closed for now. The only sliver of good news was for EB5 investors, where the dates for certain categories jumped forward significantly, offering a rare opportunity for those with the capital to invest. These whiplash-inducing changes prove that you can no longer be passive in this process. You have to monitor the Visa Bulletin like a hawk. If you want to stay ahead of these shocking bulletin changes, make sure you subscribe and hit the bell for instant updates. Checks Your Life Online is now an open book for immigration officers. Every single application form now asks for every social media handle you have used in the last 5 years. This includes platforms like Facebook, Twitter, Instagram, TikTok, LinkedIn, and even accounts you may have deleted. Government algorithms and officers are now actively scanning everything: your public posts, your photos, your likes, and in some cases, even your direct messages if they become part of an investigation. They are building a profile of you as a person. What are they looking for? Anything that contradicts your application. Any old joke you made about a green card marriage, any comment about a cash job you took in college, any controversial political opinion, or even a picture of you visiting your home country that doesn't line up with the dates you provided, all of it can be used to deny your case on character or fraud grounds. You need to perform a full audit of your entire digital history right now. Go back 5 years and look at what you've posted, liked, and shared. In this new era, your online presence is as much a part of your application as your birth certificate. So what do you do right now? In the face of these aggressive new policies, you need a clear and immediate action plan. Here are 3 things you must do this week. First, go to the official USCIS website and download the brand new August 2025 editions of every single form relevant to your case. Do not use forms saved on your computer or given to you by a friend. They are almost certainly outdated. Trash the old ones. You must start over with the new editions to avoid that instant denial we talked about. Second, become completely obsessed with every single detail. Use a ruler to measure your photo dimensions. Read every instruction for every form twice. Double-check every date, every address, and every name. Make sure every signature is in the right place and in the right color ink if specified. Create a checklist and go over it again and again. In this zero-tolerance environment, perfection is the only acceptable standard. Third, if you have a lawyer, you need to ask them 2 very direct questions today. Is my child at risk of aging out under the new final action date policy? And can I still file my adjustment of status based on the August Visa Bulletin? If the answer to either of those is yes, or even maybe, you must push to file everything this week. Do not accept delays. The window of opportunity could close at any moment. The ground has shifted beneath our feet. If you feel overwhelmed, anxious, or even terrified by this information, that is a completely normal and justified reaction. The August 2025 rules are a complete system reboot, and they are designed to be unforgiving. This is not a drill, it's a deliberate shift to a system that rewards absolute perfection and brutally punishes the smallest error. But there is still hope. The applicants who act fast, who are obsessive about perfecting their evidence, and who file before the next Visa Bulletin can still succeed. If you wait, if you hesitate, if you assume your old plans are still valid, you risk having the door to your future in America slammed shut. Subscribe for more urgent updates. Share this video with anyone you know who is in this process, a friend, a coworker, a family member, and ask your questions in the comments below. I'll be online answering as many as I can, because in this new reality, nobody can afford any more surprises.